Hello, welcome to what is hopefully the first of many events on the Modern Criminal Law Review Plus. I am Abhinav Sekhri. I am a practicing lawyer in Delhi. I usually work on criminal law evidence and procedure. And today I am joined by old friends and new. Gautam Bhatia is a lawyer also practicing in Delhi, but also across the world. And he specializes in constitutional law, not only in respect of India, but also growingly in respect of Kenya, if I may say so, Gautam. I am also joined by Rocío Lorca Ferreccio from Chile. Rocío is an associate professor of law and director of research at the University of Chile School of Law. And her research focuses on the philosophy of punishment and the interaction between criminal justice and other spheres of justice. And along with Rocío, we are very happy to have Iñigo Ortiz de Urbina from Spain, who is a criminal law professor who specializes in white-collar crime and corporate crime, criminal lawmaking, which brings us very close to what is our topic for discussion today. Not very happy that India is in the spotlight for that, but nevertheless, so be it. As all of us who have joined the live stream would probably be aware, the topic of discussion today is criminalizing sedition, the Indian debate in the international perspective. The order of proceedings is going to be as follows. I'm going to open up the discussion, followed by Gautam, who is then going to be followed by Rocío, who is then going to be followed by Iñigo. And after their individual contributions, we're going to shift to a panel discussion, which I will try my best to moderate. And there's also going to be a Q&A based on the questions that people offer up in the YouTube chat, which I have along with me. So that's whoever has questions when the time comes, even during the individual presentations by the panelists, please put them up in the chat and I'll do my best to make sure that they're addressed by the relevant person or by the panel. Now, in the short time that I have, what I wish to do is to try and set out the stage first at the smaller and more granular level of India, and then try and present it at the more fundamental level so that it connects across jurisdictions, because the question that we are dealing with is actually one that easily spans jurisdictions. It's a question that goes to the very heart of nation states, be that liberal democracies, be those autocracies, be those any other configuration. Right now, India finds itself in a moment where the offense of sedition is now due to be considered by the Supreme Court of India, reconsidered as I would have it. The Supreme Court first considered the validity of the sedition offense in 1962, and around 60 years later, it has agreed that a reconsideration is due. At the same time, just earlier this year, the Law Commission of India, which is a government body, had authored a report on whether or not the crime of sedition ought to be retained on the statute book, and wholeheartedly supported its retention, barring some alterations to make sure that the abuse which it acknowledged was happening over time can be suitably redressed. And lastly, amidst all of this, the union government is currently coming up with draft laws to replace the three criminal codes, as I may call them, that have defined India's criminal law architecture for nearly 150 years. And although there were some suggestions that the crime of sedition may well be repealed, a consideration of the draft code suggests that this certainly is not the case within the penal code itself, with a much broader version of sedition, probably in the offing. Which brings me to the first interesting point at the granular level, is that even though the debate in India has been about the crime of sedition in one manifestation. That debate often forgets that the crime of sedition has many manifestations. It's like a hydra from Greek and Roman myth that has many heads across different legal contexts, different statutory contexts, causing different consequences for various people. And the hydra-headed nature of the offense has been with India while it was a colony under the British. It stayed with India when it became independent immediately after 1947, and it continues to be the case even as India is a maturing democracy. So when we consider sedition, it becomes important to remember that sedition has not one but many manifestations. And in this, India is not unique. And probably Rocío may touch upon this. This is something that is true for other countries as well, and Chile is no exception to this, where if not the offense being called sedition, the ingredients of the offense are certainly how we understand sedition across the world today. Which brings us to what is this crime? What has been the case so far? What prompted almost all of the British Empire to have various statutory manifestations of a sedition offense? What prompted almost all nationalist leaders across these colonial contexts to have prosecutions against them for sedition? Famously, today happens to be the birth anniversary of MK Gandhi, or Mahatma Gandhi as he's called, and he was prosecuted very infamously for sedition. And during his trial, he called it the prince amongst the political offenses in the Indian Penal Code. What brings us to this, and this links to Marcus's scholarship on the point as well, is perhaps the idea that criminal lawmaking comes from a very paternalistic perspective. It was, is, and probably will be a very paternalistic exercise where any criticism of that superior authority becomes something that is not looked upon favorably. Be that a superior authority in the nature of a sovereign ruler that rules over subjects, or be that an elected government that is holding charge for the citizens. Is that what makes sedition so attractive an offense across time and space, across jurisdictions that were earlier colonies and are now independent democracies? I wonder, and probably that is something that the panelists may touch upon today in their different presentations. But that certainly is one common characteristic that has made this offense so popular across jurisdictions. For instance, we are in the wake of news around the January 6th incident and the convictions that are coming in. And if for those who were not aware, those prosecutions again have been under sedition, where there haven't been trials, but those convictions are for the sedition offense as it is in the US federal law. So it's not just something that, let's say, India is dealing with. It is not something that countries other than so-called former colonies are dealing with. This is an offense that retains its attraction across the world. So its popularity, its core understanding, all of which is something that I hope Gautam will shed more light upon in his presentation, bringing forth an avenue from his experiences dealing with free speech and constitutional law, not only from the Indian perspective, but also from the Kenyan and South African perspectives. Probably also touching upon what allows courts to turn a blind eye to what is a very vague and uncertain offense, much like, let's say, obscenity or other such harmful speech, where on any other day, that vagueness may be deemed fatal to a criminal statute. But when it comes to speech that the courts themselves think is so fundamental to make sure that the fabric of society is maintained, then suddenly that vagueness doesn't become a problem. It becomes part of the solution instead. So without much further ado, Gautam, why don't I hand over the space to you?
Yeah, thanks, Abhinav. It's really interesting, actually, that today, while I was just scrolling through Twitter, or X as it's now called, I saw some tweet about the fallout of the Catalan referendum a few years ago, and I suddenly remembered that the law of sedition was deployed to some extent in that at that time. So, it's really interesting that we have here with us Indians and someone from Spain, because I think that actually is, and like you said, it's not just colonies who are using the provision, but actually it's being used beyond that as well. So just coincidentally, I came across that and I remembered that, yes, there was the deployment of that law in Spain a few years ago. As far as the Indian story goes, it is so. What I'll try and do is I'll try and take everyone through the evolution and history of sedition law in India, and attempt to address the basic question of why it is, because this is the question that people normally ask. Why is it that the law, which was used by the colonial government directly and admittedly to suppress political dissidents, to suppress annoying publishers and press and journalists, and to stifle the nationalist movement, that very same provision was then deployed by the nationalist or independent government and upheld by the Indian Supreme Court? And I think that there are two answers to that. One has to do with a broader issue of ideology around the Supreme Court, specifically when it comes to criminal statutes, then which is summed up by this idea that the court believes that these repressive draconian provisions are necessary to exist because they serve a certain deterrent function. They serve the purpose of giving the state the powers it needs to quell, certain kinds of threats to its existence and to stability. At the same time, the court retains great faith in its ability to prevent abuse as and when it comes up. So what the court always does is, in these kinds of provisions, it upholds their constitutionality, so they stay on the statute book. At the same time, it purports to read them down and to always maintain to itself the power to check abuse as it happens. So the court will always strike down any provision that takes away its power to review a provision or an act. It will maintain the power to review exercise of state power, but it will not strike it down. It won't strike down the law that grants the state that kind of power. That's one. And the second is that when people say colonial continuity, in the history of the post-colony, it is true at multiple levels. And at one level that it is particularly true is that in the Indian case, what was the old federal court, which was staffed by judges who became judges at least in part because of loyalty to the colonial regime, just carried on as the court in independent India. So unlike the South African case or the Kenyan case, where there was an active attempt to alter the composition of the high courts and actually staff the courts with individuals who had suffered under the old regime and were therefore well aware of what could happen when state power is abused. In the Indian system, judges literally went from administering colonial law to administering the Indian constitution. And in a wonderful post that Abhinav has published today on his blog, he points out that there was a judge called Justice Das, who was actually a member of the Indian civil service. So basically, he was a civil servant who was implementing colonial policies. And he goes on to become a Supreme Court judge who's tasked with, deciding on questions of free speech and the Constitution. So how do you ever expect any kind of, pro-liberty or pro-speech judgments from judges whose career was spent in the colonial service? So these are I think, the two main explanations for why these provisions are still there in the Indian Constitution, even after in the Indian law, even after the Constitution came into being. So as far as the history of the provision goes, so of course it interestingly it wasn't there in the original Indian Penal Code that was enacted in 1860. So it wasn't a part of that penal code. It comes into being in the 1890s as a result of the Wahhabi movement, and the British government wanted an extra legal tool to check the Wahhabi movement. So they introduced the sedition provision 124A. That's why it's 124A in the Indian Penal Code, not 124, because that A, it comes in during an amendment after the original Penal Code. And right from the beginning, there is a battle over the interpretation of the provision. What does it mean? And so you have judges who begin to narrow it down, and the government responds by amending the provision, giving it a wide meaning, and changing the words, making them wider scope. And then there is this ongoing battle about both the interpretation of the provision, and also the nationalists begin to use it as a performance. So when the nationalists, the Indian freedom fighters, are accused of sedition and they're tried in the dock, they make use of this as political theater, and to show that, look, not only are we owning up to what we did, but we are not even contesting our trial under sedition, because we accept that we are in the business of spreading disaffection against the government. You have many famous examples of this. Gandhi, of course, is the most famous one, but even the sedition trial of Tilak, Bal Gangadhar Tilak, sort of a right-wing nationalist freedom fighter, a conservative, perhaps the more appropriate word than right-wing. Those categories weren't so clear back then. A conservative Indian freedom fighter. He is prosecuted on multiple occasions. In fact, on occasions for bringing out certain kinds of cultural performances that are deemed threatening by the British. And he uses sedition as a tool for making a political statement, a political performance. And if you read the judgments convicting him, you see that coming out very clearly. So broadly, I mean, the sedition provision is used in three ways. One is to quell the nationalists, to stifle them. One is against the press, the Indian newspapers, and with various other acts, which Abhinav has also pointed out, that have very similar provisions that are used. The third is that when there are cultural assertions of cultural nationalism that the British find threatening, they use sedition again as a way of quelling those. So you have multiple prosecutions of this kind in the course of the 1900s. In the 1940s, there is an interesting conflict within the British courts, where first there is an attempt to narrow down the scope of the provision by linking it to public order. So the provision only says that sedition is about bringing in the government into hatred or contempt, or exciting disaffection against the government. So the words are hatred, contempt, and disaffection. So there is a court judgment that basically says that it is restricted to that kind of disaffection, contempt, or hatred that has the tendency to create public disorder. Now, that, of course, is not supported by the text of the section. And soon after that, there is another judgment that reverses that position and says, actually, look, a plain textual reading does not support that point of view. So you have these conflicting views, judicial views, and then the Indian Constitution is framed. Independence happens, and this is 1947, and then the framers sit down to frame the Indian Constitution. Very interestingly, when they are crafting the free speech clause, they begin with the free speech clause, 19(1)(a) of the Indian Constitution, or what becomes 19(1)(a). And then they are introducing a restrictions clause. Now, this is obviously not new or strange, because other than the US Constitution, most other constitutions are framed in this two-tiered way. You have the rights clause, and then you have a set of restrictions that public order or security or defense, you have, or hate speech, you have these restrictions in the constitutional text. The interesting thing is that in the draft of the Indian Constitution, in the beginning, sedition is specifically set out as a ground of restricting free speech. So there is an explicit attempt to save sedition law under the Constitution, that you to actually say that sedition is a ground on which you can restrict free speech under the Constitution. Now, of course, there is an uproar in the assembly when this happens, because there are many people in the assembly who were imprisoned under this law, and there is an uproar. And one of the important people behind the framing of the Constitution, Sardar Patel, he tries to say, oh, this was a mistake, we'll take it out. But this mistake happens twice. It just keeps coming back. And each time, there are people who say, like, what are you doing? This is, why is this provision here? And then they take it out each time. So finally, when the Constitution is enacted, the sedition is not there in the list of prohibited grounds or grounds under which you can restrict free speech. There is security of the state, terms of that kind, but sedition finally is not there. It's taken out. And so then, of course, the question arises that now with the new Constitution, is sedition constitutional or is it unconstitutional? One would think the answer is obvious, given that it was tried to be brought in under the restrictions clause. That attempt failed. And the statement of leading Indian politicians like Prime Minister Nehru, who say that this provision is going to go, it has no place in a democracy. But as in many examples, the government says one thing and does something else. So they make no effort to actually repeal sedition. And so the battle moves to the courts. In the beginning, numerous high courts strike down the law of sedition as being inconsistent with the constitutional text. At which point, and in response to judgments of this kind, but also other judgments, Parliament, which is under the domination of the Nationalist Congress Party, amends the Constitution. And they introduce public order as a ground of restriction upon free speech. Now, recall that there was this conflict of views before independence, that do you understand sedition as the words disaffection, contempt, and hatred in that provision as only being that kind of disaffection, contempt, and hatred that leads to public disorder, or is the language broad enough to cover all kinds of sedition, all kinds of disaffection, contempt, and hatred? That is the key debate. And many courts basically say that now, after the Constitution, this provision is clearly too broad. It's overbroad, it's beyond the constitutional scope, and they strike it down. The matter then moves to the Supreme Court. The Supreme Court upholds the sedition law in 1962 on the basis that insofar as it has been held previously that only that kind of speech that leads to public disorder or the tendency towards public disorder is defined as sedition, that definition is consistent with the constitutional text, because 19(2) of the Constitution does say that the state can make reasonable restrictions upon free speech by law in the interest of public order. So if you read the sedition provision as being only that kind of speech that tends towards disorder, that is constitutionally valid. Now, there are two problems with this, of course. One is that there is a massive gap between what the text actually says and this reading that the court has given, because the text just says disaffection, contempt, and hatred. The court is effectively reading in a public order requirement into this provision. The problem is, of course, that now at the level of implementation, the arrests for sedition will be made by the police. At the first instance, your liberty is dependent on the trial court understanding this doctrine and applying it in this way. Now, that then depends on the branches of the Indian judicial system working in a certain kind of harmony, where the Supreme Court's doctrine that it lays down is understood and applied in that spirit across the board by all other courts. That has never been true in the Indian legal system. And in fact, that and the reason for that is that is not only that the proclamation doesn't happen, but also the court's own doctrine is so vague that it doesn't really give any genuine guidance to the trial courts. So tendency to create disorder is a very wide term. It could mean anything. And so trial courts have no real guidance, and that then leads to on the ground prosecutions happening en masse. So that is the story of Indian sedition, and I'll conclude by coming back to the 2 points I made at the beginning of my remarks. One is that what the judgment in Kedarnath Singh, the court that upheld sedition, shows is what I said, that the Supreme Court, and this is true across the board, genuinely believes that these kinds of provisions are necessary, because in that case, the court talks about that the state must have the tools to defend itself against threats to its own existence. It believes these laws are necessary. It also believes that it and the courts around it, in the lower courts, will check abuse when it happens. That second premise is completely flawed, and that has been the reason why these prosecutions continue to happen. And the second point is that there was never a break between the colonial period and independence in terms of who was actually deciding these cases, and therefore that distrust of state power, which we think is a hallmark of constitutionalism at its best, was never a story of the Indian Constitution. And that's also why these provisions exist and have been upheld instead of being struck down. So that is the story of Indian sedition law. I'll stop there and hand over to my co-speakers.
Rocío, why don't you take the conversation forward, if you may, please?
Okay, yes. Thank you. Thank you so much, Abhinav and Gautam, for your previous remarks. So, yeah, I think we have a lot of things that we share, some that we don't. So I'll tell you a little bit about Chilean regulation of sedition and the practice. And then I have a few questions that I'm going to make to Gautam and Abhinav. So in Chile, sedition is both a common crime and a military crime. So there's a special crime of sedition in the military code, and I'm not going to be talking about that. As a common crime, we have it regulated in the criminal code from 1874, and the provision there hasn't changed at all. It was based actually in the on the Spanish criminal code of 1848 or something. But then we have a law that's a special law that's called the law that establishes crimes against the security of the state, which is from the 50s, and I will call here the infamous law for short. And there you find a bunch of behaviors that are not called sedition, but that broadly understood are forms of sedition. And so when I speak about sedition, I'm going to speak about all of these crimes, because given that India's regulation is so broad, these are behaviors that would definitely be seditious in your perspective. And so I will just use sedition to call all the crimes that are where political opposition is expressed and is criminalized when it's expressed either by action or by speech. In the crime that we have that is called sedition, action is required, a disturbance on the exercise of public office, but we have a lot of figures that criminalize discourse. And many of these figures that criminalize discourse that are closer to the Indian regulation, as I understand it, are not in the criminal code, but in this infamous law. And as it seems to be the case in India, it has been used in Chile as a tool against political opponents. There are two exceptional features in our regulation of sedition that I think are worth mentioning before I move to a more substantive comment, because they speak of the extraordinary and political nature that this crime has, which is similar to what we find in the anti-terrorist legislation. That has special kinds of punishments, special kinds of procedural rules, etc. And so sedition is one of the few crimes in our criminal law code that can be punished by estrangement, which is a very rare form of punishment, and also is one of the few crimes that can be punished during the stage of conspiracy and proposal. The general rule in Chile is that criminal responsibility starts with attempt. So the agent must have undertaken concrete action to commit the crime, crime, except in certain cases like the crime of sedition, broadly understood. In terms of its justification in the Chilean legal scholarship, sedition and all these crimes are considered crimes against the internal security of the state. But what exactly this means is very unclear. The security of what, right? And is it to protect the political institutions of a democratic republic? Is it to protect the rulers that sit on those institutions? And these questions has been discussed in Chile and has been considered relevant because if what we're aiming to protect is the stability of institutions because they create a democratic arrangement, and this seems to be the acceptable option for us today, then crimes of sedition or even rebellion, when they are committed against de facto rulers or against anti-democratic rulers, some say are not or should not be considered sedition. Our practice, however, shows that clearly this is not the case, and therefore democracy is not what is guarded here, because these crimes have been rarely applied against those who actually have threatened or harmed our democratic institutions, and instead have been used by those who have harmed democratic institutions to limit political debate and repress political opposition. So to put a little bit more concrete history into this, let me offer you a view of the evolution of this infamous law during the 20th century. The infamy of this law has to do with its origins and its application. So since the 30s, we have laws that aim at protecting democracy by restricting political opposition, limiting freedom of press and the freedom to organize politically. In the beginnings, these laws were created as a reaction to the workers' movement, but the infamous law was established in the 50s, in the era of McCarthy, Senator McCarthy's anti-communist position in the beginning of the Cold War, and it was placed to replace a previous regulation that had taken things a bit too far and had actually declared illegal the Communist Party and had severely limited freedom of the press. So that anti-communist law, which actually was the reason why Pablo Neruda, a famous Chilean poet, had to flee the country because he was a congressman from the Communist Party, that anti-communist law was replaced by the infamous law as an attempt to make it more democratic. However, it didn't quite manage to accomplish this goal because in practice it was widely used against the Communist Party by Pinochet in the 70s when he made his coup d'état, and he took this law and made it bigger, wider, vaguer, more severe, and more clearly targeted against political dissidents. And so even though they don't mention communists, it was used clearly against left-wing politicians. With this, he consolidated the state of terror that reigned the country for 17 years. But of course, he used many other even worse tools to create and keep terror. And so once we returned to democracy in the 1990s, many people said, we have to get rid of this law because this law was the legal tool when Pinochet was not torturing, people. He was using this law and others to repress political opponents. So, but instead of getting rid of the law, we passed some reforms and we eliminated what Pinochet had added. And what happened is that in practice, governments refrained from using it. So it wasn't used very much because in order to use it, the prosecutors can't use it by themselves. It has to be kind of triggered by governmental action, by the executive power. And so it hasn't been used much in Chile until now, until 2019. What happened in this period is that the internal enemy against whom this infamous law was targeted changed. Is no longer the Communist Party or the Socialist Party, but rather a new internal enemy, which has been indigenous people organizations and some social movements that usually those who go to protest in the street. particularly against Mapuche indigenous organizations. Against them, the Chilean government used the anti-terrorist law for a long time, rather than the crimes of sedition, because there was this taboo that you couldn't use sedition crime because it was like what Pinochet did, and this ended in the case of the Mapuche this year, where they used the sedition law to prosecute a very important Mapuche leader for the crime of inciting and defending the use of violence as a means of social transformation. So that's one case that's been really important. And then in 2019, we had what's called the Chilean Estallido, which was a series of social protests that took place starting in October of 2019 until March 2020, basically because the pandemic came. It was a very intense social movement. People basically went to the street to protest about, social unfairness, many different things. It wasn't a coordinated thing. It was very spontaneous, and it got pretty violent. And the government at that time called these protesters a powerful enemy, and called the use of legal tools to fight it a war against a powerful enemy, and started using the sedition law together with the ordinary crimes to prosecute these protesters massively, like hundreds and hundreds of cases. And so this was very symbolic and very important because it was a change of policy. And even though in all these cases, for Mapuche cases and in protesters, we have many legal tools to prosecute these behaviors, this decision was very important, right? So the question, I guess, we're wondering today, because this is very recent, the new government took down those cases, the sedition cases, but the precedent is there, right? And the question is, why should the government charge offenders with these crimes that are contained in this law that has no democratic credentials at all? And why it would do it when it had not used this crime to prosecute or even to speak about the actions of those who supported military interventions against democratic rule? I mean, the one time where democratic institutions had been really threatened and harmed, sedition laws have not been a part of the conversation, and so it's very makes the idea of democracy being the justification for these crimes very hard to believe. And all that's left there is really just those in power repressing those who are going against the government. So that's the kind of the basic context, and this is not to deny that this sometimes the Mapuche organizations or organizations that say that they are promoting Mapuche interests commit serious crimes, and sometimes protesters also commit serious crimes. The question is, why also to prosecute them under the law of sedition? And so I would like to conclude by formulating two questions to Gautam and to Abhinav, which is something that I started thinking when I was preparing this comment, and is, what's your opinion of hate speech crimes? Because in Chile, human rights activists and left-wing politicians who criticize very much sedition laws because of this anti-democratic ethos are promoting also criminalizing hate speech and the negation of human rights violations that took place during the dictatorship. And I find this a little bit troubling, and I wanted to hear your view, because if part of the problem with sedition is that it limits speech, and this allows for these crimes to be instrumentalized by those in power to repress political opposition, which is part of democracy, could this also happen with hate speech crimes? Do you think there is an inconsistency here, or do you think that hate speech crimes are different and that criminalizing them may be less risky for our freedom and for democracy? And is there a similar conversation in India, like this kind of tension? So that's my question. Also, of course, for Iñigo. And I have another question that's more practical. So from a practical point of view, it's not completely implausible to argue that without a law of sedition, political opponents could be prosecuted by laws that are even worse, like the anti-terror laws. This is, of course, not enough reason not to get rid of a bad law, but I wanted to see what you think of this kind of argument that is like kind of, oh, but sedition is the lesser evil of the different kind of tools that the governments could use in order to do this. So thank you very much. Those are my comments. Thanks.
Thank you. And I will come back to those when we convene the panel discussion after Iñigo's presentation. So without much further ado, Iñigo, over to you.
Well, thank you very much. Very happy to be here in this first, and I am sure that only the first of many events that we're going to be having. Thank you, Marcus, for having this initiative. And well, I was, just surprised by how fast you talk, Rocío. I mean, this is gone worse with the years. I have to say that normally I'm the fastest speaker in the room, and that's why people make, jokes about my last name being Urbina, which sounds like turbina, which is like turbine, like a very powerful motor. But in this case, I will very, very likely come only second in terms of speed, and probably last in terms of the precision of this talk. So I was approached by Marcus, and I thought, well, I mean, he said, would you consider talking about sedition? This being a huge issue in Spain. There's been a very famous, even internationally so, judgment rendered against some very high-level politicians, actually 12 very high-level politicians from the autonomous community of Catalonia. This judgment was rendered in 2019. I will go on a little bit about the specifics of the sentence, but it did involve, in 9 of the 12 cases, custodial sentences, which were counted in more than a few years of prison. So I thought, yeah, that might be a good idea. And also, I mean, you have to think that in Spain we used to have, because it's been very recently repealed, just last year, the repeal of sedition in Spanish law entered into force on January 13 this year, 2023. And prior to that, we had the crime in our criminal code from 1822 until 2022. So that's a good 200 years. But that's pretty much law in the books. And we will go on to the analysis of law in action, and we will see that, it has nothing to do with that. I mean, so in these 200 years, we have had very few decisions on the crime of sedition. We have had more decisions on the crime of rebellion, which carries more severe penalties with it, as I will explain. So sedition from 1822. By the way, Rocío was right when she said that the Spanish code that where they took their sedition offense from was 1848. Actually, the 1822 criminal code in Spain, there are serious doubts whether there was a single decision based on that code, because it was enforced only for a few days, really. So yeah, the criminal code, the first real Spanish criminal code, is the one from 1848, which lasted until 1870. As you can see, criminal codes were not very, they didn't live long, in those days. They do fare a bit better now. So as I said, Spain got some attention, or it went into the spotlight in terms of comparative criminal law, when in 2019, 12 people were sentenced by the Spanish Supreme Court for the crime of sedition. This was this caused some outrage, because these people, out of these 12 people, 9 of them were sentenced to prison sentences ranging from 9 to 13 years of duration, which just by that, you don't have to be a very serious follower like I am of Carl Llewellyn and the other American legal realists to see that something is off. How can people be sentenced to over 10 years of imprisonment for something like sedition, if sedition was defined as it is in Indian law, as we previously saw? the thing is that in Spain, sedition is not an opinion crime. It's not also an opinion-creating crime. It's not an apology of certain other forms of crime. Sedition, as Rocío explained, it's also the case in Chilean law, although they do have other provisions which can also be considered sedition. We don't have that many other provisions that we can consider provisions. Sedition, the weight of the prosecution of people who engage in speech which is considered to be conducive to a rebellion or to the dismemberment of the Spanish state is mostly prosecuted, as Rocío hinted at in her second question, by the crime of apology of terrorism. So in just partly answering to your question, I don't know whether it is any kind of justification for the use of sedition, especially in countries where, such as in Spain, sedition can carry a maximum penalty of up to 15 years of imprisonment. So I don't think that people are really worse off if they are being prosecuted by apology of terrorism, which in Spain can only carry up to 6 years. So it is not a problem of naming or nomina jure, but it is a matter of, what finally the sanctions are and how much speech of an obvious political nature you are chilling, with the use of these provisions. Well, maybe the Spanish Supreme Court thought that it was just protecting the Spanish state, and that's what it said. I'm using actually the public prosecutor office had insisted on the application, and they were charging for the crime of rebellion, which could carry an extra 5 years, so 20 years in prison. I mean, one has to laugh about it because it's just so terrible. But the Supreme Court said, no, it's not really rebellion, it is sedition. I will, come. The main difference is that in order to be able to convict for violence, for rebellion, the Supreme Court would have had to find that massive amount of plural violence was used, which did not happen, absolutely not happen in Spain. In fact, many people have referred to what happened in Catalonia as a postmodern coup d'etat, because there was pretty much no violence involved, but it was pretty close, to actually having a declaration of independence. They actually, if you want to know the details, they had a declaration of independence, but it was suspended only 13 seconds after it was proclaimed. So it was possibly one of the shortest living declaration of independence in the history of the world. So throughout the years, sedition was considered a crime, as Rocío said, against the internal security of the state. It was coupled with rebellion. And if you see the literature up to 1995, that's where the new criminal code entered into force. There was kind of an obsession with tracing family relations between the crime of rebellion and the crime of sedition. People would go and say that these two offenses were twins. Other people upgraded it to Siamese twins, whereas other people, continuing on the family naming business, said that actually sedition was, because of the lesser penalty, a little brother of rebellion. I hasten to say that I will not use this occasion, to talk about the idea of family resemblance and to quote a very famous philosopher on that, because I believe that we quote too many philosophers in many occasions where their quoting leads us nowhere. But the fact is that both rebellion and sedition were considered crimes against the state. The importance of which, this is history. I mean, and of the Spanish criminal law is not merely historical, but it did play this distinction, or this idea played a role in the events leading to the 2019 sentence by the Spanish Supreme Court. In 1995, we finally got a new criminal code. I say finally because, well, democracy came back to Spain in a very quiet manner. So our dictator died in bed in 1975, and then a series of events led to democracy being replaced in a couple of years. As of 1978, we had a new constitution, and it took us almost 20 years until 1995 to have a new criminal code. In this criminal code, rebellion was considered a crime against the constitution, so properly a crime against the state, whereas sedition changed and was included. Gautam made a comment, to the idea of public order and the how this very vague concept is oftentimes used to restrict fundamental rights. In the case of sedition, sedition was now included among as the most severe offense, but among the public order offenses. So it is no longer a crime against the state, but a public order offense. It's basically what differentiates sedition from the rest of these public order offenses is that in sedition we talk about a collective resistance. You have to have a public and tumultuous uprising. And this has to be done with the aim to impede, with the use of force or any way outside the legally provided procedures. You have to impede or try to impede the enforcement of the law or the proper exercise of their functions by public officials. So this is not directed against the state as such, but against some functions of the states in which are carried out by some of their officials. What the Supreme Court said is that even though there was no violence, and so it couldn't be said that it's difficult to make a summary of what happened in Catalonia between 2014 and 2017, but let's just say, that there's been always a part of the Catalan people who do not think that they belong in Spain. A majority of people do not really have anything against being part of the Spanish state. But there was some political crisis, huge cases of corruption for over a decade, and a very big financial crisis. And the nationalist parties in Catalonia took the opportunity to increase their political base. They promised that everything would be solved by having an autonomous government. And a lot of people bought in this kind of discourse, and not actually majority of the Catalan people, but a majority of the political representatives in the Catalonian parliament, a majority of one actually, because they were split almost 50-50, insisted that they could declare the independence of Catalonia from Spain just by voting, by a majority vote in the Catalonian parliament. This was against the Catalonian constitution, which provided that any decision just to begin with the process would need 2/3 of the votes. But they said that this was kind of a revolutionary moment, and that this constitution didn't apply anymore because this was a new constitutional moment. And then they started out, these not legal proceedings, but this path to independence. The Spanish state proclaimed, and the Spanish constitution proclaimed that it was against the constitution, and forbid that certain steps to be taken. One of them being a votation, about a vote about a referendum about whether Catalonia should remain in Spain or not. As we can all see, we saw some of us live, and you can still see it in YouTube. The Spanish police committed a very serious mistake of overreaction in trying to enforce the resolution of the Spanish Constitutional Court, which said that this referendum was illegal. They used force. They used a very serious amount of force, and because this force was also repealed by the citizens who wanted to express their political opinion in this referendum, there was a quite large number of people injured. I still wonder, why there was nobody dead. I guess that it is because in Spain we don't use guns and we don't carry guns with us, which would probably explain, so be that as it may, we were lucky enough that nobody lost their lives in these confrontations, but they were severe enough. Well, after that, there were some court cases opened against people, against perpetrators of violence on both sides. and also against these 12 high-level politicians in Catalonia. The accusation being that sedition is not really a public order crime, but is also a crime against the state. So the Spanish Supreme Court changed its view, the view that it had been having since 1995, because that's pretty much what the new criminal code says, and changed the nature of a crime against public order to the nature of a crime against the internal safety of the state. This allowed the Spanish Supreme Court to issue a judgment where these 12 people are charged with basically promoting a state of opinion, which led to this to all these demonstrations, some of them violent, mostly violence against things, and people burning trash cans and stuff like that, but also some stone throwing to the police and stuff like that. And that's why they were finally sentenced, in a decision which, well, the Spanish Supreme Court believes that it was a case of just using the criminal law to protect the state. But a lot of people in Europe do not seem to share this opinion, because the Spanish state, some of these, not of these 12 who were sentenced, but some other Catalan politicians fled Spain, and Spain tried through the usual channels of criminal cooperation between states, which are especially strong among European countries. Spain tried to get the extradition of one of the politicians, various ones, but the most famous case is the case of Puigdemont. He tried to get him extradited first from Germany, then from Belgium, and both countries denied the extradition, saying that what they had done wasn't really a crime against the state, and that the prosecution for rebellion and even the prosecution for sedition was too much. Well, also internally, a lot of people thought that it was too much. It doesn't matter whether you consider sedition to be a crime against public order and not against the state, if you can impose sentences which are counted on tens of years. So what the Spanish government did in June 21, so that's almost 2 years after the sentence, it issued a partial pardon, which basically put everybody out of prison, even people who were serving terms for 13 years. This was a partial pardon, but it was encompassing enough to make that the remaining of the sentence for everybody was less than 2 years, and so they could be put out of prison. This didn't seem enough. There were still many cases who were to be tried. This case went so far. I mean, you have to take into account that a lot of the events took place in 2017, and in just 2 years we had a Supreme Court judgment. That's because given the high level of these politicians, they were tried directly by the Supreme Court. So the Supreme Court issued a judgment in first and last and only instance, but the rest of the cases were being investigated in Catalonian courts, and they were being tried in courts of first instance, so they would take a lot longer to reach the Supreme Court. Besides the pardons, what the Spanish Parliament did, and this was done, as I said, 10 months ago, sedition was repealed, and it was substituted for, so the content of sedition was included as an aggravating circumstance for the offence of public disorder. It still can carry 3 to 5 years of imprisonment, 5 to 7.5 if firearms are actually used, but it is a lot less punishment than it previously was done. There is still a question of whether this is enough in order to set us back to a time where we could actually talk to each other about, the adequate placement, the adequate place of Catalonia in Spain, if it needs to be in Spain, which is to be politically decided. And now we are also because of nobody can really form a government now. The Catalan parties are asking for an amnesty to everybody involved, also the policemen involved in the police forces involved in these events, in order to vote for the more progressive political party which is trying to get to the government. Wow, that was maybe too messy, but it's a lot of real events, with a very high political importance, which just goes to show the malleability of offense definitions when we are trying to when a court, in this case the Supreme Court, believes that it needs to defend the state. These vague provisions were adapted, even though they were since 1995 considered a crime against public order. They were switched back to being a crime against the state, so that no real affectation, specific affectation of public order by these people, but the idea of they generated this climate which was conducive to all the events that happened in these 3 years, and this finally resulting in this legal mess that we are still trying to solve, and nobody knows really how to do it. Thank you very much for your attention, and I look forward to the Q&A. Thanks.
Thank you. That was a really interesting and really short, actually, summary of what was a very complicated prosecution from whatever I had followed of the proceedings as and when they were happening back in 2019. So we have a few questions, and what I thought is that I'll try and mesh in the questions with the comments that I had while hearing all of your presentations. Obviously, looking specifically at the 2 points that Rocío had also put while making her presentation. The first of these, and this is going to be, this is like a broad framing that looks at some of the questions as well as Rocío's points, which is what really then is the problem with sedition? Now, is sedition a problem today because it curbs speech? And then that links to Rocío's point about, well, if that's the problem, then how does it fit in with offenses such as hate speech that are also curbing speech? And therefore, how do we get into the categorization of differentiating between these? So what is the problem with sedition from that perspective, but also from the perspective of, let's say, criminal law principles? And that speaks to a question that's come in the chat, which is something that Iñigo mentioned towards the end of his presentation, that you have offenses that are so inherently malleable that not only is it possible to and that also speaks to the Indian experience, where courts have the ability to practically rewrite offense definitions and practically re-christen the offenses while interpreting them to achieve purposes and objects that the court then starts to think is the object or the purpose that ought to be achieved with this offense. So is that also a problem with having an offense like sedition? Or is there some more fundamental problem with having crimes that basically are built upon the idea that the state should be allowed to use the power of its criminal laws to force people into having some sort of adherence, some sort of respect for the idea of the state itself? So then that speaks to the paternalistic idea of the nation state and using criminal laws to enforce that feeling of political obligation, as it were. And is that then the problem? And then that speaks to, again, a point that Rocío had made about replacing sedition, or rather presenting sedition as a lesser order crime, in fact, where you are today in the field where countries across the world are actually dealing with this kind of conduct with anti-terror laws, where conduct that might be seen as too critical of the state is also only a step away from being treated as a terrorist offense or something that falls within that realm. So how do we understand the problems with, or are all of these problems with sedition, right? So is sedition such a big issue? Because it's not just one of these, it's actually a problem on all of these fronts. And which is why perhaps country legislatures have decided to repeal the offense, where courts have perhaps not done so. So that's the first point that I would want the panelists to consider. And the second point, and we can sort of frame the discussion along whichever point you guys want to take up first, is about, again, something that came up in Iñigo's speech, which is about the practical implementation of these laws, and also Rocío's speech at that point, which speaks to the interaction between sedition on the one hand and police and administrative laws on the other. So I'll just sort of give an example from the Indian perspective. In India, one thing that makes sedition such a problematic crime is that sedition is one of those offenses that allows the police to arrest people without warrant and also results in no right of bail. So India has a peculiar regime where a large category of offenses don't carry any right of bail. Bail is completely at the discretion of the court. And the police also have a very vast scope of authority when it comes to arresting persons without warrant. And this categorization is offense specific. And since 1970, sedition has been one of the offenses that allows for this to happen. So what happens then in place is that while there is one set of problems with the criminal codes sort of saying that this kind of criticism is a problem, you have a very different problem on the ground, because even though courts might disagree with, whether or not speech was or was not seditious, in the moment, the law confers the police the power to go on the ground, break up a protest, and send people into buses to police stations and force them to give bail. Otherwise, sends them into custody. So that link between political speech or any crimes for that matter with the police and administrative legal regime is something that I'd also want the panelists to maybe shed a little bit more light on from their own legal jurisdictional experiences, or even other experiences for that matter, because I thought that sort of adds or maybe reduces the bite of sedition, depending on where we are and what courts then have to do as well. And lastly, perhaps this speaks to the first point. What about the roles of the different arms of the state when we think about offenses like sedition or any offenses dealing with political speech? So then it comes to the legislature that sort of decides to retain it. And we saw with the experience of all three countries, India, Spain, as well as Chile, that you have legislatures agreeing that we should not have this crime, but still sort of wanting to retain it. And then you have the executive that thinks that, we should not be enforcing it, but then sort of doing it either under the guise of sedition itself or lesser order sedition, or so as whatever it may be. And then for me, at least from the Indian perspective, the most interesting is the court's relationship in all of this. And perhaps now from what I've learned about the Spanish experience, even from Spain's perspective, where you find courts also have a very important role in either sustaining the legitimacy of the offense, where they are also equal participants in sustaining the ideas of what is important for the nation state and what is necessary to, sustain the idea of, crimes against the state, and be that as a speech that can threaten the very existence of the state itself. So, leaving it to the panelists to decide what question they might want to tackle first. My personal preference is for the police administrative law questions for various reasons, but over to you guys, and I'll try and moderate to the best of my ability, but I think anyone can sort of take the floor.
I was faster than Rocío. I saw that she was moving towards the mouse, so I said it. Let me intervene. I'll try to be brief. Also, I forgot to say that I wholeheartedly recommend everybody who is watching or hearing us, to visit the materials, because as you just said, one of the problems with sedition, as with many other offenses, is not whether people in the end get sentenced for it, but also the policial uses of these offenses. I was shocked, to see this very nice empirical report about the uses of sedition in actually in part of India. It is an amazing empirical report, and I recommend, because you can actually do that with many offenses. And this is something that, if you recalled in the article by Wilson and Kelling, Broken Windows, they actually said, but this was Wilson's saying, he says, I don't like the harm principle, and I don't need the harm principle, because what I want is the police to be able to operate. And if this is a crime or not, I don't care. If people finally go to prison, I don't care. I want the police to be able to intervene. And this is what we see in many of these offenses. They create pathways for the police to operate, and then maybe courts, or maybe don't, will just cartel what they did. But in the case that you cannot be put into bail, that has an immediate effect. The chilling effect of that, it's so huge. In the case of Spain, and it is very, it goes straight to the point what you said, how a court, even if it's the Supreme Court, can say, well, I take it on me to defend the state, and rebellion was against the state and sedition was against public order. But I will forget about what I said before, and now sedition is also against the state. I will very briefly, and I can do this because there is not so much, go through every single case of sedition which was tried in the Supreme Court of Spain from 1980 until 2022. This is 42 years. On 1980, a group of citizens were sentenced because they were trying to stop a judicially ordered eviction, and they used force. They were sentenced for sedition, but it was said, that there was a minor case of sedition, so they applied sentences which were only 1 year of imprisonment, not 10 to 15 years, just one. And they also said that there was a mitigating circumstance, that they acted upon humanitarian reasons, so to say, well, we have sentenced them to a custodial penalty, but they're good people, nevertheless, The second case was a case in 1991, so that's 11 years later. This is, again, a group of neighbors, always neighbors, who rather strenuously oppose a water transfer decision. So now we have water coming from this river and it's going to go to this other municipality. No! And they used some force. Nobody was injured nor anything. That they were accused of sedition. The Supreme Court said, no way, no way, no way. That's not against the state. That's against the functioning of, a local municipality. Not enough for sedition. They were sentenced for coercion to a non-custodial penalty. The third and last case until 2022 was a case where, again, a group of neighbors which were angry with their city council. Apparently, they were very angry because they set the city council premises on fire. They probably didn't think that it would burn so easily, but it did burn, and nobody was injured, but, everything went up in flames. Well, again, they were sentenced, they were accused of sedition, and the Supreme Court said, no, this doesn't go against the state, even though, they actually burned, some premises which could be taken to mean that they used some violence against, those premises or whatever it is, and they were sentenced for public disorder. So in this, we have three cases, only three previous cases. In two of them, there was an accusation, but the sentence was not passed for sedition because there was, and in the case that it was for sedition, people only got 1 year because all the mitigating circumstances and factors were taken into account. And suddenly, 30 years later, 28 years later, a case like this goes to the Supreme Court, and all these previous judgments account to nothing, and sedition is interpreted as rebellion was in other cases. The malleability of these crimes is just so huge that they pose an inherent problem for a healthy democracy.
Rocío, Gautam, your thoughts?
Yeah, do you wanna, well, on the thing that, the last thing that Iñigo says, I think, I mean, I wonder what's that makes this crime so malleable, right? And I guess one could think, oh, it's the way in which they are defined, or is the kind of interest they are protecting, or it's just that always political institutions will try to find and will manage to find some crime that they can use to do this. I mean, if you have sedition, you'll use sedition. If sedition changed to something else, or you will keep an interpretation of sedition or whatever. So I'm not completely sure, but I think there is something about the harm principle that and the legality principle, right, that helps limiting this a little bit. And these crimes have both problems, right, are very, in the Indian case, clearly are very broad kinds of behaviors. And also, in terms of the harm principle, it's really not clear that this is a kind of harm that we should protect through criminal law in a democracy. And also, what is the harm? Because it's not, at least in our regulation, it's not clear. Yeah, it has to do with public disorder, but also with stability of institutions. So that allows for like a very broad and opportunistic application. And I think that really, for me, speech is also like, you know, like just having a crime that consists of saying something that can create, that has an effect on some other people's behavior, just seems very dangerous, because it does allow for a lot. And that's my worry with hate speech crimes, that even though, you know, I think it's important to have a normative conversation about hate speech and maybe sanction it socially, using it as a crime would provide with a political tool that I think could be dangerous. But I want to address the thing about the police, because it's interesting. I haven't looked at it so much from that point of view, but it should, because we don't have, so what would happen here in the protest, which is when these crimes have been used lately more, it's that police would detain people, and since it's very hard to prove, for instance, crimes against property or crimes against, I don't know, bodily integrity or life, because you detain 100 people, you don't know who threw the stone, you don't know who threw the Molotov or whatever, you can't really prosecute them. So you can keep them detained for up to 24 hours, and then you had to let them go. Unless you use these kinds of crimes, which, because they're more broad, they're a little easier to prove, because the police can show that the person was attacking them, and this can, but even though that could be a reason, most cases in Chile are very, it's not like to enable police, I would say, but it's more to, it's more a symbolic use of the law by the state, because very often the state presents the charges and then retreats them, takes them away. There are very few convictions with this law. So it's used to show, here we are, this is the power of the state, and we are going to prosecute them, not just with common crime, but with these political special crimes. And in this rhetoric, to show, you know, that the public order is back again, but it's very selective politically on who you are using this, you know, public order demand, and then it's taken back. And so I think that in our case, at least, it's more symbolic about authority than about enabling the police, because actually I don't know that it's so useful for that purposes, because you still have to prove some things, subjective things. And so I think in the end, it's more this kind of rhetorical usefulness rather than anything else. So I pass it on to Gautam.
Yeah, and Gautam, I hope you can try and look at that specific point that Rocío had made about India and while she was making her presentation as well.
Sorry, which one? Which specific point? The hate speech.
The specific, yeah. So
Yeah,
one
no,
was the
I'll
hate speech
address that,
point,
yeah,
and the second one was about how political dissidents could be dealt with using various other offenses.
I was going to address both points. Yeah, yeah. So I think on the sedition point itself, you've pretty much dealt with the procedural aspects under Indian law. So I think I don't need to reiterate that. And I'll just one thing I'll add is, since you've expressed some curiosity about the philosophical justifications for a law like this. I think the interesting thing is that in that judgment, Kedarnath Singh, where they uphold sedition, they do spend some time dealing with the phrase government established by law, right? Because the provision of the sedition, the language of the sedition provision under Indian law is disaffection, contempt, hatred against the government established by law. And the court in that case says, okay, yeah, the individual governments might come and go, but the idea of the lawfully established government is what the section's about, and no lawfully established government can basically countenance its own overthrow. So there is that the idea of a constitutional government having, in fact, a right to preserve itself, and sedition being the tool that it uses to preserve itself before it gets to the actual overthrow of the state, is the ideology that comes through in that case. Of course, it's an inconsistently applied ideology, because there are cases where people chanting secessionist slogans have been found not to be, guilty of sedition. But then again, that's 10 years after the movement was strong. So there is a bit up and down over there. But that is, I think, the ideology that comes through in that case. Now, on these two questions, both very interesting questions, hate speech. So I think I broadly agree with you. So I mean, in India, we have a problem. We are flooded by hate speech, and that's hate speech that targets minorities, that targets them with respect to economic boycotts, social boycotts, and violence. And there is a direct link between these calls for boycotts, for violence, and actual violence on the streets. This is exactly what we have seen over the years. You have seen how blood libel against Jewish people then leads to ghettoization, leads to pogroms. We're seeing the same trajectory in India. And the line is very clear. So I think that conceptually and theoretically, the case for restricting hate speech is clear, and and most countries that do not share of the extremist views of the US do have hate speech regulations. And I don't think conceptually there is a controversy here. And Jeremy Waldron, in his book The Harm in Hate Speech, and many other books, sort of make that conceptual case, I think, quite strongly. And the problem is, as you say, is that ultimately your laws on hate speech will be implemented by people. And if those people carry the same social biases and prejudices that animates the people who make the hate speech, then there's no point. And in fact, you will weaponize hate speech laws against dissidents. So there is a distinction, for example, in, say, a country like Canada or, say, Germany, where there is a clear social consensus across the board that, for example, Holocaust denial or anti-Semitic speech is hate speech. So there is that clear social consensus, which makes the enforcement of hate speech laws against anti-Semitic speech, relatively straightforward when it comes to, anti-Semitic hate speech. I'm not talking about the controversies around the IHRA, things like that. No, that apart, what is very clearly anti-Semitic hate speech can be enforced because there is that prior social consensus that this is hate speech and this is wrong. In a country like India, and I guess in Chile as well, if that doesn't exist to start with, then your implementation of hate speech law is going to necessarily be a problem, because the police and often parliamentarians and indeed courts invariably share the same majoritarian biases that lead to it in the first place. So you're effectively asking the same group to police itself, and that never really works out. I think in India, what we are seeing, therefore, is that hate speech happens all the time. The police is ineffectual when it comes to actually enforcing existing hate speech laws against that, and the courts are equally useless. I mean, they're completely useless. in doing anything. When you go to them with an issue, they either delay or they pass an order that is like so laughable that it's like a joke, right? And it can't be enforced. So I think that's the problem. A second question, other kinds of laws. So I think this is a really valid point. It's been my opinion throughout that the case against sedition that is ongoing in the Indian Supreme Court is a red herring in many ways, and is actually I mean the whole reason why the Indian court has suddenly, after all these years, decided to reconsider sedition is like, it's like a PR move. Because if you look at what happens in cases involving political dissidents, if you look at Indian political prisoners right now, and there are many political prisoners in Indian jails, the legal provision that they have been imprisoned under is not sedition. It's something called the Unlawful Activities Prevention Act, which is the anti-terror legislation in India. And that basically is the law that the police uses when they want to deny someone bail and keep them in jail for many, many years. And that's the law under which the courts, barring a few honorable exceptions, just refuse to grant bail no matter how laughable the case is. And so tomorrow the Supreme Court might strike down sedition. First of all, that might itself be useless, because now we have new bills, new criminal law bills that sort of recast that offense altogether. So, but that apart, the Indian Supreme Court might strike down sedition. What will only happen is that the police will then use the UAPA, where they were earlier using sedition, and that will lead to the same kinds of outcomes. So I think that you're completely right. Again, you can dispense with the sedition law, but until you have courts that are determined to fashion legal doctrines that will preserve liberty, what we now call sedition will come back in another name, and already is there. So that would remain a problem.
Just to sort of jump in, and we have around 3-4 minutes left before I start giving my effusive thanks to everyone, including Marcus, for having done this. Just a thought that I was having, which is the problem then at a much deeper level, just nation states. I don't know how better to frame it, but ultimately it is this structure that is so fearful about its own existence that whoever is sort of at the reins has always wanted to have the power to enforce compliance, to have adherence, to have fealty, loyalty, and punish disloyalty. And that's literally the definition of sedition in India still. Disaffection and disloyalty is what is punished. So even with the coming of liberal democracies or modern states as we understand it, maybe that fundamental reordering of the nation state and the citizen state relationship is actually still something that maybe we take too much for granted. And it's something that actually has a long way to go in terms of that shift from, Iñigo mentioned the Spanish criminal codes, evolution over time, and maybe the underlying assumptions that sort of undergird these criminal codes are still a way off from the popular pronouncements of politicians and from on either side of the spectrum, as it may be. So just a thought that I was thinking about while listening to all of you. Thank you so much for taking out the time on a Monday for all of us, Monday night for some, Monday evening and Monday afternoon for others. Again, thank you so much, Marcus, for taking this initiative forward and making the Modern Criminal Law Review possible. And I hope that everyone who saw this might see this later on, found the discussion as insightful as I did. Again, please check out the page, and there are resources to look at. There are going to be more interventions to follow, and there are going to be more events in the future. And one is already scheduled, so please take your time out and give it a look. Thank you, everyone, and see you soon.